Okay, so picture this for a second. You walk into your boss's office, you hand in your resignation, and you walk out. On paper, you quit.
Right.
But in the eyes of the law, you might have actually been fired.
And that's the whole paradox of what we call constructive dismissal.
It sounds a bit like a corporate buzzword, doesn't it? But it's this real legal idea where, well, your employer changes your job so much.
Like a massive pay cut or a demotion.
Or even just creating a completely toxic environment, so much so that you feel like you have no choice. You're forced to leave.
Exactly. It's treated as a termination because the employer basically broke the contract first.
And the number one reason for these kinds of claims, workplace harassment.
Mm-hmm.
So to figure out if you've been fired this way, you first have to understand how the law even defines harassment.
Which is a lot trickier than most people think.
It really is. So today, we're diving into the legal reality of workplace harassment right here in Ontario. We're using analysis from HTW Law, and we're looking at two big pieces of legislation.
The Ontario Human Rights Code. We'll just call it the code.
The Occupational Health and Safety Act, or OHSA.
Our mission here is to sort of untangle these two. Because they do overlap, but they protect very different things.
Different zones, almost.
Yeah, that's a good way to put it. The code is all about discrimination. It protects your identity, race, age, sex, that sort of thing. OHSA, on the other hand, is about safety in the workplace. It covers violence and general harassment that isn't necessarily tied to your identity, but is still hostile.
Okay, so let's get into the weeds with OHSA first. The analysis mentions something called the manager's shield.
Right, this is a crucial distinction. Under OHSA, for something to be workplace harassment, the conduct has to be vexatious.
Vexatious.
But, and this is a big but, there's a specific carve-out. It says, reasonable action taken by a manager.
Like giving you feedback on your work or setting deadlines.
Exactly. That is not legally considered harassment.
Wait a minute. So if your boss is writing you constantly, creating all this pressure, making you stay late, that can create a toxic environment, right?
You'd think so, subjectively. But under the law, not necessarily. Even if it causes you a ton of stress, if it's considered reasonable management, OHSA won't touch it. It has to cross that line into vexatious.
So what's the actual difference
Right.
between just stressful and legally vexatious?
Well, it comes down to objective versus subjective. Harassment isn't just about you feeling bad.
That's subjective.
Right. Vexatious means the conduct is objectively known or should be known to be unwelcome. It's about the aggressor's actions, not just your personal reaction to them.
That feels like a pretty high bar. So does it have to be a pattern? I mean, does one bad joke count?
Under OHSA, you generally need a pattern. The definition is specific. A course of comment or conduct.
Of course.
So a single incident is almost never harassment under that Safety Act.
But the Human Rights Code is different.
Very different. Under the code, a single incident, if it's, egregious enough, can create what's called a poisoned work environment.
Poison. That's a strong word. What does it actually mean?
It means the environment has become so hostile, so damaging, that it's just not psychologically safe to be there. And this brings us to a really important case, George v. 1735475, Ontario Limited.
Okay.
Because this case just blows the lid off a huge difference in liability.
Wait out for us.
So in the George case, the tribunal found an employer made racial remarks that were severe enough to poison the environment. Now, for standard harassment, an employer isn't automatically on the hook for what their employees do.
They usually get a chance to fix it if they didn't know about it.
Usually. But the code has this special provision for a poisoned work environment. It basically works like a strict liability clause. Meaning if the environment is found to be poisoned, the employer is liable, period. It doesn't matter if they knew or if they tried to fix it.
Whoa. So for regular harassment, a boss can claim ignorance, but if the place is poisoned, that's no excuse.
That's it, precisely. The law says this environment is your responsibility, full stop. It completely bypasses that we didn't know defense.
Okay, so we've got the manager's shield in one corner and this strict liability trapdoor in the other. What about where this all happens? Does it have to be at the office?
For OHSA, yes. It's tied very strictly to the workplace. But the code doesn't actually define workplace. It can cover off-duty conduct.
Really?
If there's a clear relationship between the people involved that stems from work.
So for you listening, trying to sort out if you're dealing with just a bad boss or actual illegal harassment.
It really comes down to these specific legal definitions.
Is it management or is it vexatious? Is it a pattern or is it one incident so bad it poisons everything?
And crucially, is it tied to protected grounds like your race or gender? Because that changes the liability completely.
Before we go, I want to leave everyone with one final thought. You mentioned the code can reach outside the office?
Yes. There's a Supreme Court case, British Columbia Human Rights Tribunal v. Schrank, that established what's called the sufficient nexus test.
And this is the part to really mull over. If harassment doesn't even have to happen in the workplace to be actionable, as long as there's a sufficient nexus, a connection to your job.
Then where does your employer's authority and their responsibility actually end?
Does it follow you to the weekend barbecue? Something to think about. Thanks for diving in with us. We'll see you on the next one.